Sperling, where I practice in trust and estates and trademark law.
Hi, my name is Moreau Williamson. I'm an assistant state's attorney in Anne Arundel County, Maryland, assigned to the Felony Narcotics Unit. During this program, we are going to be talking about the definition of AI and common legal applications. Common examples of AI applications relevant to lawyers include tools that draft, text, summarize documents, extract key facts from large records, assist with legal research, and help organize discovery or medical and financial data. AI tools are best viewed as assistive technology. AI offers significant benefits. Most notably, it can dramatically improve efficiency. Tasks that traditionally consumed hours, reviewing thousands of pages of records, summarizing deposition testimony, or drafting first-pass memoranda, can often be completed in minutes. AI can also enhance consistency by applying the same analytical framework across large data sets. For example, AI can quickly summarize a 500-page medical record and compare pre- and post-incident functionality, allowing counsel to spend more time refining legal arguments. These benefits, however, come with meaningful risks. AI tools can generate inaccurate or incomplete outputs, often referred to as hallucinations, and they lack legal judgment. An AI-generated answer may sound confident while being factually wrong or unsupported by the record. Over-reliance without independent verification can lead to factual errors, flawed legal analysis, or ethical issues. Lawyers remain responsible for the work product, regardless whether AI assisted in creating it or not. Security and confidentiality concerns are particularly critical for attorneys. Many AI tools process data on third-party servers, raising questions about where client information is stored, how long it is retained, and who may have access to it. Uploading privileged, confidential, or sensitive personal information to unsecured or consumer-grade AI platforms, which are free, can risk waiving privilege or violating professional conduct obligations. In Course 2, the program focused on the ethics and professional responsibility that lawyers should observe when using these highly technical AI tools. At a minimum, lawyers should understand the data handling policies of any AI tool, including whether inputs are used to train models, whether data is encrypted, and whether the vendor offers enterprise-level security and confidentiality protections. Additionally, Course 5 provides more detail on content-specific AI vendor terms for lawyers to negotiate. In short, AI is best viewed as a powerful assistant, not a substitute for legal experience. When used with appropriate safeguards, it can meaningfully enhance modern legal practice while preserving ethical duties to clients and the courts. Once we understand both the benefits and risks of using AI in legal practice and apply protection or mitigation measures to comply with our ethical and professional responsibilities, the next and critical question becomes this: how do we control the output? It turns out that AI tools are only as good as the instructions they receive. For lawyers, that's good news, because prompting isn't a technical skill, it's a lawyering skill. A well-written prompt dramatically improves accuracy, relevance, and usefulness.
Think of the LLM like a witness on the stand. It will answer the question asked, but not always the question you meant to ask. If the response is vague, incomplete, wrong, or dodges the key issue, that's on you to follow up. Just as you would never accept, "I don't recall," without probing, you shouldn't accept a shallow AI response without pressing for specifics. Let me give you an example. A bad prompt is something like, "Summarize this testimony." That's vague. There's no time frame, no subject limitation, no guidance on what matters legally. The result is usually unfocused and unusable. A good prompt sounds more like a well-planned direct examination. It defines the scope, limits irrelevance, and demands accountability. For example, summarize the plaintiff's medical history since the accident only, including diagnoses, treatment, providers, and functional limitations. Exclude pre-accident history unless needed for context. Cite page and line references. That prompt sets boundaries and produces something you can actually use. Of course, sometimes when we receive a new case file, we just want to get a broad understanding of the facts. And in those cases, we may want a 30,000-foot summary overview. Think of prompting AI the same way you think about direct examination. On direct, you control the narrative by asking structured, intentional questions. You decide the order. You establish timeframes. You avoid irrelevant detours. The same approach works with AI. Break complex requests or tasks into logical sections. Ask for one category of information at a time if needed. Providers, diagnoses, treatment, limitations. You can always ask the LLM to combine the information in a final step. When you do this, the output becomes clearer, more accurate, and easier to verify. A good prompt is nothing more than a clean, direct exam. Now let's talk about cross-examination. AI tools can be evasive or just wrong. They may gloss over inconvenient facts, omit key details, or give you a polished answer that lacks actual substance. When that happens, treat the response like weak testimony. Call out the defect explicitly. Tell the LLM what it failed to address and instruct it to fix the problem. For example, you did not address post-surgical treatment, or you failed to describe functional limitations. Then ask for a revised answer. Practical tip, lawyers who get the most value from AI are the ones who cross-examine instead of passively accepting a first answer. In sum, AI answers questions the way witnesses do. It answers what you asked, not what you meant. The better lawyer examiner you are, the better AI assistant you have. Now that we've talked about how to question and prompt AI tools effectively and understand that good prompting is really just good lawyering, we can move on to demonstrate where AI tools truly shine. One of the strongest, most reliable, and immediate uses of these tools in legal practice is document review and summarization. How many of you have spent hours reading a record just to extract a timeline or a medical summary? Or have you assigned a junior associate or law clerk to do it? See, this is where AI tools can offer real, immediate value. While AI is evolving rapidly, there are still areas where we can overreach or produce unreliable results. Summarization, however, plays directly to the current strengths of these tools. Lawyers work with large volumes of text, depositions, medical records, police reports, pleadings, and that AI is very good at distilling that information into structured, readable summaries. Importantly, this does not involve AI creating new facts or legal theories. Instead, it is synthesizing existing information that you, as a lawyer, can verify and rely upon. And used properly, summarization allows lawyers to save time on volume while maintaining full professional judgment and control. This is a very common everyday use case that most lawyers will immediately recognize. Reviewing legal correspondence, don't we all? We routinely receive letters or emails from opposing counsel.
Can I break in for just a second? If there's any time you want to redo something, feel free to stop and say, yeah. So anytime you trip up and you want to redo something, I'll just edit that part out and you can redo it.
Yeah, let's go to the top of that slide. It started with right after I finished, use properly, summarization allows lawyers to save time on volume while maintaining full professional judgment and control.
Yeah, that's a lot. So
we can say
yeah. Yeah, that'd be great. Yeah.
Okay.
Let's do it. That way I can search through the transcript for the cut and we'll
take it from the top.
All right. Perfect. Thank you.
All right. Action. This is a very common, everyday use case that most lawyers will immediately recognize reviewing legal correspondence. We routinely receive letters or emails from opposing counsel, insurers, experts, or clients, and we often need to quickly understand two things: what the key points are and whether we need to respond. This prompt shows how AI can help with that task efficiently and safely. The objective here is narrow and well-defined. We are not asking the AI to analyze the letter's legal merit or to suggest a response. We are simply asking it to summarize the content. The prompt specifies a word limit, which is important because it forces clarity and prevents the output from becoming unnecessarily verbose. It also tells the AI exactly what to look for, key points, and whether the author is requesting or expecting a response. Notice the last instruction: do not add analysis, legal opinions, or assumptions. That is critical. We want the AI to stick to the text of the correspondence and not to speculate about intent or legal implications. The result is a short, clean summary that allows you to decide quickly whether action is required, whether the letter needs deeper review, or whether it can be handled later. Think of this as a time-saving intake or triage tool. It gets you oriented quickly, but you remain in control of the legal decision-making. AI works best when you tell it exactly what you want, and just as importantly, what you don't want. Let's look at a very practical, real-world example: summarizing a deposition transcript. Most of us have dealt with lengthy depositions, 200, 300, sometimes even more pages. Reading and rereading those transcripts is time-consuming, but we still need to quickly understand what the witness said, where the key testimony is, and how it affects liability and damages. This is where AI tools are extremely helpful. Instead of asking the AI to analyze the case or draw conclusions, we use it for what it does best: organizing and summarizing existing testimony. In this example, the prompt tells the AI exactly what we want: background on the witness, a chronological account of how the incident occurred, testimony related to injuries and treatment, admissions, and inconsistencies. We're also telling the AI to use headings, and most importantly, to cite page and line references. The result is not something you blindly rely on. It's a roadmap. Instead of starting at page 1 and reading straight through, you can go directly to the critical testimony, verify it, and use it for mediation prep, motions practice, or trial strategy. Think of this the same way you would think of a junior associate or paralegal summary. It saves time, but you still review and confirm it. The difference is that this can be done in minutes rather than hours. AI doesn't replace reading the deposition. It replaces reading it inefficiently. Lawyers still check the citations to the record, but instead of reading 250, 300 pages, you're reviewing a structured roadmap for preparation for mediation or for trial.
Another area where AI tools are particularly effective for lawyers is in creating chronological outlines or timelines. Most cases involve multiple documents created at different times: depositions, medical records, emails, police reports, pleadings, and one of the hardest early tasks is simply understanding the sequence of events. AI tools are very good at extracting dates and organizing information in chronological order. Instead of manually flipping between documents and building a timeline by hand, AI can provide a structured first draft in minutes. These timelines are useful at every stage of litigation. Early on, they help lawyers understand the case's story. Later, they help identify gaps, inconsistencies, or missing documents. They are also extremely helpful for mediation, dispositive motions, and trial preparation. Importantly, AI-generated timelines are not final products. They are starting points. The lawyer still verifies the dates, confirms the source material, and refines the narrative. Used properly, AI allows lawyers to spend less time assembling timelines and more time analyzing what those timelines actually mean for liability, damages, and strategy. A real-world example of an incident timeline. Why this prompt works. It clearly defines the scope and purpose. It forces chronological structure. It requires citations for verification. It prevents speculation or legal conclusions. And it produces a usable foundation for motions, mediation, or trial prep. This is another very practical use of AI tools that fits naturally with how lawyers already think about evidence and testimony. In many cases, we have multiple statements from the same witness. An initial statement given at or near the scene, a police or incident report, recorded interviews, later deposition testimony or written affidavits, maybe testimony from a motions hearing. And comparing those statements manually can be time-consuming and easy to miss subtle differences. AI tools are well suited to assist with this comparison. They can organize statements side by side and highlight where facts change, where details are added or omitted, where language becomes more precise or more vague over time. This does not mean the AI is judging credibility. That remains entirely the lawyer's role. What the AI does is surface the differences so that lawyers can quickly see where testimony evolved and decide whether those changes matter. This is particularly useful for deposition preparation and cross-examination. Instead of rereading every prior statement, you can focus on the specific areas where the testimony is inconsistent or materially different. Used properly, this kind of comparison saves time, sharpens examination strategy, and helps lawyers make informed decisions about how to address credibility issues without outsourcing judgment or advocacy to the tool. Practical tip: AI does not decide credibility. It helps lawyers decide quickly to see where testimony has changed so they can decide what matters. A real-world example in comparing witness statements for a robbery. Why this prompt works. It treats the AI like a comparison tool, not a credibility judge. Forces topic by topic organization that mirrors cross-examination prep. It requires citations for verification and impeachment planning, and it prevents speculation or argumentative framing. A real-world example of using AI to brief case law. Why this works. It mirrors how lawyers already brief cases, produces a usable study and reference tool, and saves time on first pass case law review. Keeps legal judgment with the lawyer, not the AI.
One of the most useful early applications of AI in litigation is reviewing the sufficiency of a complaint. At the outset of a case, we are often trying to answer basic but critical questions. What exactly is being alleged? Are all the required elements pled? And are there obvious weaknesses that might support early motions practice? Can I start over, please? All right, action.
Yeah, of course. Yeah, cut. We have to put in a cut and an action here.
Scene.
I need one of those things.
Yeah.
The clapper.
Yeah.
This is the slide at top of slide 22. One of the most useful early applications of AI in litigation is reviewing the sufficiency of a complaint. At the outset of a case, we are often trying to answer basic but critical questions. What exactly is being alleged? Are all the required elements pled? And are there obvious weaknesses that might support early motions pleadings? AI tools are particularly strong at this type of structured analysis. They can quickly organize allegations, flag missing elements, and summarize what the complaint does and does not say. Importantly, this does not replace legal judgment. AI helps ensure that nothing obvious is overlooked, but it is still the lawyer who decides whether and how to challenge the pleading. In Maryland, false imprisonment, civil, is a common law tort, which means we analyze it element by element rather than by statute. When using AI to review a complaint, the goal is to confirm that each required element is actually alleged, not just implied or conclusively stated. We want to know, does the complaint plead intentional confinement? Does it allege a lack of consent? And does it affirmatively allege an absence of legal justification or authority? AI is very effective at mapping allegations to elements and highlighting gaps, which can be extremely helpful when evaluating whether a Rule 2322B2 motion to dismiss may be viable. Beyond the elements, AI is also useful for quickly assessing exposure. Complaints often include broad or scattered allegations of damages. AI can help identify exactly what categories of damages are being requested, such as compensatory damages, emotional distress, punitive damages, or attorney's fees, and whether those damages are pleaded specifically or generally. AI can also confirm whether the plaintiff has requested a jury trial and identify where that demand appears. This is important for early case evaluation and strategy decisions, particularly when advising clients about risks and litigation exposure. Sorry, let me say that one again. AI can also confirm whether the plaintiff has requested a jury trial and identify where that demand appears. This is important for early case evaluation and strategy decisions, particularly when advising clients about risks and litigation posture. Another valuable use of AI at the pleading stage is identifying affirmative defenses that may appear on the face of the complaint.
Can I stop you there? It looks like you're somehow muted. I'm hearing you through everyone else's mic, but I tried to unmute you, but
I'm not muted.
no? Strange.
How long has that been going on?
I didn't see it earlier.
It sounded
It didn't
normal.
mute.
Yeah, it does sound good. I don't know why it's saying that. That's unusual.
I muted to take a sip of water when Moreau was speaking, but I unmuted and I'm still unmuted.
Okay. All right. I mean, I'm hearing you fine. So, and we're getting signals. So, just double checking. We're good.
Okay,
So
no.
we'll add a cut and a action.
Which one is this? This is slide 25. Another valuable use of AI at the pleading stage is identifying affirmative defenses that may appear on the face of the complaint. While defenses are typically raised in an answer, taking our earlier example of the civil complaint for false imprisonment, certain defenses such as legal justification, consent, lawful authority, probable cause, or statute of limitations can sometimes be apparent from the plaintiff's own allegations. AI can help flag these issues early, allowing counsel to think strategically about motions practice or early resolution. Again, the AI does not assert defenses for you. It simply helps surface potential arguments so that lawyers can exercise judgment and take the appropriate legal steps. At the pleading stage, AI is most powerful as a structural tool. It helps lawyers see the case clearly, early, and completely.
This is a particularly powerful and sensitive use of AI tools, especially for criminal defense and civil rights practitioners. Police reports and related documents often contain a detailed narrative, but the constitutional analysis requires us to break that narrative into discrete steps: the initial encounter, the stop or seizure, the justification offered, and the scope of any search. Doing that manually across many reports can be time-consuming. AI tools can help by organizing the facts in the police report to align with traditional Fourth Amendment analysis. For example, the AI can identify what the officer states justified the stop, when the detention began, what facts were cited as reasonable suspicion or probable cause, and when and how the search occurred. This is especially useful in stop and frisk or traffic stop cases, where the legality often turns on the sequence of events and whether the officer articulated specific, objective facts before taking action. AI can help surface whether those articulable facts are actually present in the report or whether they appear only after the evidence is discovered. Importantly, the AI is not assessing whether the search or seizure was constitutional. That judgment remains entirely the lawyer's role. What the AI does is help lawyers efficiently extract, organize, and visualize the facts so they can apply Fourth Amendment standards and decide whether to pursue a motion or other challenge. Used correctly, this tool saves time, increases consistency in analysis, and ensures that potential constitutional issues are identified early, without delegating legal reasoning to the technology. AI can help identify where a Fourth Amendment may exist, but only a lawyer decides whether to make it. And there are benefits for both sides. The prosecution can verify a stop, search, and arrest, and the defense can determine the merits of a motion to suppress and the likelihood of success. This example is designed to show how AI tools can assist lawyers in conducting a structured Fourth Amendment analysis without deciding constitutional issues. The facts here are intentionally familiar: a traffic stop for a broken taillight, seeing contraband in plain view, a sequence of searches, and increasingly serious evidence being discovered. This is exactly the kind of case where the legality turns on sequence, articulated justification, and scope. The prompt is written to force the AI to break the report into discrete stages: the initial stop, seeing the contraband, the search of the driver, the search of the passenger, then the search of the trunk. This mirrors how lawyers and judges actually analyze Fourth Amendment issues. Notice what the AI is not being asked to do. It is not asked to say whether the stop or search was constitutional. It is not asked whether to suppress the evidence. It is not asked to speculate about the officer's intent. That is deliberate. Those are legal judgments that belong exclusively to the lawyer. Instead, the AI is being used as an organizational and analytical assistant. It helps identify what justifications and law enforcement claims for each step, whether those justifications are tied to specific facts, and whether there are gaps or conclusory statements that may be vulnerable. Sorry, can I start that paragraph?
Yeah, of course.
Or just that? Okay, so action. Instead, the AI is being used as an organizational and analytical assistant. It helps identify what justifications and law enforcement claims for each step, whether those justifications are tied to specific facts, and whether there are gaps or conclusory statements that may be vulnerable to a suppression challenge. In practice, this kind of output gives the lawyer a clean roadmap. You can quickly see where reasonable suspicion begins, where probable cause is claimed to arise, and whether any warrant exceptions are invoked. That allows you to efficiently evaluate suppression issues, prepare motions, or advise a client without reading the report multiple times, trying to reconstruct the timeline. The key takeaway is this: AI accelerates the fact organization, not constitutional decision-making. When used this way, it saves time. Practice tip: AI doesn't decide whether evidence should be suppressed. It helps lawyers see where the issues are. This follow-up prompt shows the next step we've used AI to organize the facts of a traffic stop or arrest. At this stage, the lawyer already understands the sequence of events and justifications law enforcement states for each action. The purpose of this prompt is not to have the AI write a finished motion to suppress. Instead, it asks the AI tool to help build a structured outline or analytical framework that mirrors how suppression motions are actually argued in court. Notice how the prompt is organized around stages of the encounter: initial stop, detention, searches, and seizures. That's intentional. Fourth Amendment analysis is almost always step by step, and this structure helps ensure we don't collapse distinct legal issues into a single argument. The prompt also asks the AI to associate potential Fourth Amendment issues with each stage, such as lack of reasonable suspicion, lack of probable cause, improper scope, or impermissible prolongation. I'm sorry, can I cut? I'm going to do that paragraph again. Action. The prompt also asks the AI to associate potential Fourth Amendment issues with each stage, such as lack of reasonable suspicion, lack of probable cause, improper scope, or impermissible prolongation. This helps surface issues quickly, especially in issues with multiple searches or multiple defendants. Importantly, this prompt instructs the AI not to invent facts, speculate, or predict how the court should rule. That preserves ethical boundaries and keeps legal judgment where it belongs, with the lawyer. In practice, this kind of AI-generated outline can save significant time. Instead of starting from a blank page, the lawyer receives a clean, organized framework that can be refined, supplemented with jurisdiction-specific case law, and tailored to the factual record. AI is being used here as a drafting and organizational assistant, not as a strategist or decision maker. When framed this way, it enhances efficiency without undermining professional responsibility or independent legal analysis. This slide brings together everything we've discussed so far: fact organization, legal frameworks, and responsible drafting, and shows how AI can be used to mirror how experienced lawyers already work. The key here is that lawyers can upload their own materials into an AI tool. That includes their motion to suppress example, the statutes and case law they routinely rely on, and all of the relevant police reports and discovery. This is not asking the AI to invent arguments or styles. It is asking it to work within the lawyer's existing structure. When done correctly, the AI uses those inputs to populate the template with case-specific facts, organize arguments under Fourth Amendment frameworks, and generate a coherent first draft. What that replaces is the repetitive front-loaded work, copying boilerplate, formatting headings, and drafting background sections from scratch. What it does not replace is legal judgment. The lawyer still decides what arguments to include, what authority controls, whether to file the motion at all, and how aggressively to pursue the suppression. This drafting process should be treated exactly the way you would treat a draft prepared by a junior associate. You review it line by line. You verify every citation. You edit for tone, strategy, and accuracy. Nothing gets filed without attorney review and approval. Used this way, AI doesn't cut corners, it frees up time. Instead of spending hours on mechanical drafting and formatting, lawyers can use that time to refine arguments, prepare for hearings, and advise clients. A practice tip: AI can help you get to a strong first draft faster, but professional responsibility, accuracy, and strategic decisions remain entirely with the lawyer. This workflow starts from a place that should feel very familiar to practicing lawyers. You are not asking the AI to invent a motion or guess at your firm's style. You begin by uploading your own motion to suppress template, the same one you already rely on in practice. Step one is template control. By providing your firm's template, you're telling the AI exactly how the motion should be structured, what headings to use, how arguments are organized, and the general tone and formatting expected by your court and judges. Step two is grounding the AI in authority. You upload the statutes and controlling case law you want applied. This keeps the analysis anchored in the law you already rely on and reduces the risk of hallucinated or irrelevant citations. The AI is constrained to work only within the materials you provide. Step three is providing the factual record. You upload the police reports, arrest reports, and other discovery materials. This allows the AI to pull the relevant facts directly from the record and place them into the appropriate sections of your template, such as the statement of facts or argument section. Step 4 is prompting for a first draft only. The prompt explicitly instructs the AI to generate a first draft motion, not a final filing. It also tells the AI not to invent facts, not to add new legal theories, or not to cite authorities beyond those uploaded. This keeps the tool in the role of a drafting assistant, not a decision maker. Step 5, and this is the most important step, it's the lawyer review. The AI's output should be treated exactly like a draft produced by a junior associate. You review every section, verify every citation, refine the arguments, and make strategic decisions about what stays in and what comes out. Nothing is filed without attorney approval. When used this way, AI removes the repetitive mechanical drafting work, copying boilerplate, formatting sections, and populating the background facts, so that lawyers can focus their time on analysis, strategy, and advocacy. The lawyer controls the template, the law, the facts, and the final product. The AI simply helps you get to a solid starting draft faster.
This workflow is about hearing preparation, specifically being ready not just to argue your motion, but to handle questions, pushback, and counter arguments from both opposing counsel and the court. Step 1 is grounding the AI on what already exists. The lawyer uploads the filed motion along with the statutes and case law cited in it. This ensures that AI is working from your framing of the issue, not a generic legal problem. Step 2 is providing the factual record. By uploading the documents and evidence that support the motion, police reports, discovery materials, affidavits, or exhibits, you give the AI the same universe of facts that the judge and opposing counsel will be relying on at the hearing. Step 3 is asking the AI to synthesize, not decide. The AI is instructed to identify arguments that support the motion and separately arguments that cut against it. These against arguments are not admissions. They are stress tests. They reflect how opposing counsel may frame the facts or how the court may question your position. Step 4 is using the output as preparation, not briefing. The purpose of this exercise is not to generate new filings. It is to prepare for oral argument, anticipating weaknesses, refining responses, and avoiding being surprised at the platform. Just kidding. You see how I just make up words? Like it's how I make up things. Let me go back on that one. Step 4 is using the output as preparation, not briefing. The purpose of this exercise is not to generate new filings. It is to prepare for oral argument, anticipating weaknesses, refining responses, and avoiding being surprised at the podium. Step 5 is lawyer refinement. The lawyer reviews the AI-generated points, decides which counter arguments are realistic, and prepares responses that align with the record and governing law. This stage sharpens advocacy without delegating strategy to the tool. Conceptually, this is no different from moot court or playing devil's advocate before a hearing. The AI simply allows lawyers to do this preparation more efficiently and consistently. AI can help lawyers see both sides of the argument clearly, but the lawyer decides what matters, how to respond, and how to advocate in court. Now, you can do the same thing with an opponent's motion or the response to your motion. This slide addresses one of the most familiar and time-consuming parts of legal practice, research and case analysis. We all know this well. Traditionally, legal research has required running multiple keyword searches, reviewing long lists of cases, and manually determining which authorities actually matter. AI tools change that workflow by allowing lawyers to start with natural language questions, much closer to how we actually think about legal problems. Instead of guessing the right Boolean search string, a lawyer can ask the AI to identify relevant cases, summarize holdings, or compare fact patterns. This doesn't replace traditional research. It layers intelligence on top of them. Instead of guessing the right Boolean search string, a lawyer can ask the AI to identify relevant cases, summarize holdings, or compare fact patterns. This doesn't replace traditional research tools. It layers intelligence on top of them, helping lawyers get oriented faster. AI is also particularly useful at the analysis stage. Once cases are identified, AI can summarize opinions by breaking them down into facts, issues, reasonings, and holdings. This allows lawyers to quickly understand large volumes of authority and focus their time on the cases that are most persuasive or controlling. Another major benefit is comparison. AI can help identify similarities and differences across cases, highlight recurring legal themes, and flag distinguishing facts. This supports stronger argument development and helps lawyers anticipate how courts may view an issue. It's critical to emphasize what the AI is not doing. The AI is not deciding what the law is, predicting outcomes with certainty, or making strategic judgments. Lawyers must still verify every citation, confirm that the authority is current and controlling, and decide how to apply the law to their case. Used correctly, AI functions like a highly efficient research assistant, one that helps lawyers spend less time sorting through material and more time exercising judgment, advising clients, and crafting arguments. The key takeaway is that AI accelerates research and analysis, but responsibility and accountability remain squarely with the lawyer. AI helps you find and understand the law faster, but it's still your job to decide how to use it. Now, this prompt is a good example of how lawyers should think about using AI for legal research. Narrowly, deliberately, and with clear purpose. Step 1 is framing the factual issue precisely. In this scenario, we're dealing with a classic Maryland premises liability slip and fall case, where liability often turns on actual notice or constructive notice and the reasonableness of the store's response. The prompt clearly lays out the key facts: a reported puddle, a 2-hour gap, a fall in the same location, and conflicting testimony from the janitor. The factual clarity is critical. Step 2 is constraining the jurisdiction. The prompt explicitly limits the research to Maryland cases. This is essential. Premises liability law is highly state-specific, and Maryland has its own standards for notice, inspection, and proof. Without that constraint, AI tools can easily drift into persuasive but irrelevant authority from other jurisdictions. Step 3 is asking for balanced research. Notice that the prompt does not ask the AI to find cases that support my claim. Instead, it directs the AI to find cases where stores were found liable and cases where they were not. This mirrors good lawyering. Understanding the adverse authority is just as important as understanding favorable cases, especially when preparing for summary judgment, trial, or settlement. Step 4 is focusing on reasoning, not results. The prompt asks the AI to summarize the facts and the court's reasoning, particularly around notice, time on the floor, and conflicting testimony about cleanup. That's the analytical work lawyers actually need. The AI is not being asked to say who should win. It's being asked to surface how Maryland courts analyze these situations. Step 5 is comparison and application. By requesting a comparative analysis, the prompt helps the lawyer identify what factual details Maryland courts find decisive, how long a condition existed, whether it was reported, how credible the cleanup evidence is, and whether a jury question actually exists. That comparative framing is what allows a lawyer to assess risks and strategy in their own case. Finally, and most importantly, the AI's output is a research starting point, not an end product. The lawyer still reads the cases, confirms the holdings, checks for accuracy, and decides how to use or distinguish the authority. The value here is efficiency, completeness, not delegation of judgment. The takeaway for practice is this: when you use AI with a prompt like this, you're essentially giving yourself a faster, broader first pass at Maryland case law, while keeping strategy, credibility, assessment, and advocacy entirely in the lawyer's hands. This next slide focuses on one of the most immediate and practical uses of AI in transactional practice: contract review and contract drafting, my favorite. Step 1 is contract ingestion. Lawyers upload an existing contract, whether it's a counterparty draft or an internal agreement, into an AI tool designed for legal work. The AI can read the entire document in seconds, which is especially valuable for long or repetitive agreements. Step 2 is the first pass review. The AI helps identify and surface key provisions such as indemnification, limitation of liability, termination, confidentiality, governing law, and assignment. This saves lawyers from hunting clauses. Let me back up. Step 2 is the first pass review. The AI helps identify surface key provisions such as indemnification, limitation of liability, termination, confidentiality, governing law, and assignment, among other things. This saves lawyers from hunting clause by clause and ensures that nothing obvious is overlooked during an initial review. Step 3 is risk spotting and comparison. AI can flag non-standard clauses, missing provisions, or deviations from a firm's preferred language or playbook. This allows lawyers to focus on the provisions that actually pose legal or business risk rather than spending time on boilerplate that is acceptable. Step 4 is drafting or revising. Lawyers can use AI to generate a first draft of a contract or specific clauses based on templates, prior agreements, or firm standards. Importantly, this is not a final document. It is a starting point that reduces time spent drafting from a blank page. Step 5 is lawyer review and judgment. Every AI-generated suggestion remains just that, a suggestion. The lawyer reviews, edits, accepts, or rejects proposed language based on jurisdiction, deal context, client objectives, and professional judgment. Nothing is finalized without attorney approval. The key takeaway for contract lawyers is efficiency without loss of control. AI removes large portions of mechanical review and drafting work, enabling lawyers to focus on negotiation, strategy, risk assessment, and client counseling. Used correctly, AI enhances consistency and speed while preserving the lawyer's central role as decision maker and advisor. Practice tip: AI can read and draft contracts very quickly, but only lawyers can decide what contracts should actually say. The next slide provides a concise example of how a lawyer can use AI as a first pass contract review assistant when working with an event, use, or venue agreement. These agreements tend to be time sensitive and heavily negotiated, so efficiency matters, but so does risk control. The workflow starts by uploading the event use agreement into the AI tool. The lawyer then directs the AI to focus only on the provisions that typically carry the greatest risks in these deals: indemnification, insurance, choice of law and form, and termination. Rather than asking the AI to analyze the whole contract, the prompt narrows the tasks. I'm going to go back to the paragraph before that because I mumbled on forum. The workflow starts by uploading the event use agreement into the AI tool. The lawyer then directs the AI to focus only on the provisions that typically carry the greatest risks in these deals: indemnification, insurance, choice of law and forum, and termination. Rather than asking the AI to analyze the whole contract, the prompt narrows the task. This is important. Narrow prompts reduce noise and help ensure the AI surfaces the clauses lawyers actually care about in this context. For each of those clause categories, the AI is asked to quote or summarize the relevant language and flag unusual, unclear, or one-sided terms. That gives the lawyer a structured overview of how risk is allocated without replacing legal judgment. Notice what the AI is not being asked to do. It's not deciding whether the clauses are enforceable, whether they should be accepted, or how they should be negotiated. Those decisions remain entirely with the lawyer. In practice, this type of AI review saves time by quickly orienting counsel to key provisions and allowing them to focus their attention on negotiation strategy, client risk tolerance, and jurisdiction-specific concerns. The takeaway is that AI can help lawyers see the contract clearly and quickly, but it does not change who is responsible for advising the client or finalizing the deal. In sum, AI helps you get to the issues faster. Note, you can also follow up prompts for redlining the contract as well.
So here's the professional bottom line. AI is an assistive technology in legal practice. Lawyer judgment goes in, the scope, the law, the purpose, ethics, and the AI tool, an assistant, summarizes, organizes, compares, drafts, structures large volumes of material, and then the lawyer conducts review and examination to verify, question, correct, and refine, to ensure that the final product is strategically sound, factually accurate, ethically compliant, and lawyer authored and approved. We want to close by grounding everything we've covered today in this framework. At the top of the diagram is lawyer judgment, because AI only works as well as the scope, purpose, and constraints we give it. That means the law, facts, ethical boundaries, and tasks all come from us, not the tool. In the middle is the AI itself. And what you've seen today is that AI is exceptionally good at doing the heavy lifting lawyers spend enormous amounts of time on: summarizing, organizing, comparing, structuring large volumes of material, and generating first pass drafts. But that output is not the end of the process. It flows directly into lawyer review and examination. Just like a witness, the AI answers the question that it's asked, not the question we wish we asked. So we verify it, challenge it, narrow it, and correct it using the same professional skills we already have. And only after that process do we reach the bottom of the diagram, the legal final work product, strategically sound, factually accurate, ethically compliant, and fully owned by the lawyer who signs or relies on it. The key point is this: AI changes the workflow, not the lawyer's role. It accelerates preparation and organization, but judgment, accountability, and responsibility never leave the lawyer's hands. Thank you. They cut.
All right, that was great.
Oh, thank you.
Very cool. So I'm going to stop recording and we're going to make sure that